Taken at face value, the concept of adoption cannot be considered as anything other than acting in a child's best interests.
Adoption is a process whereby a child's legal relationship with their birth parents is replaced by one with adoptive parents. Original birth records are sealed and a new birth certificate is issued as if the child had been born to the adoptive parents. An adoption order legally makes the child the adoptive parent's child as if born to them in lawful wedlock. This promotes the child's welfare by providing a permanent, secure family unit and gives adoptive parents greater certainty because adoption is difficult to revoke. The additional legislation supports the Adoption Act in facilitating adoption.
Maori perspectives on adoption are grounded in values like tapu, whakapapa, whānau, and arawa, which shape the understanding that tamariki are taonga. These values underpin the tikanga of whāngai, which is a customary caregiving practice where a child is raised within their whānau network, not through severing parental rights, but through strengthening whakapapa connections. Tamariki whāngai remain linked to their birth mātua, their culture, and their wider whānau, with decisions made collectively to ensure that their mana is protected and their tapu respected. This provides an essential foundation for understanding the Maori approach to caring for tamariki and highlights how it differs from Western legal adoption.
The legal status of whāngai has shifted over time. This is despite its legitimacy, practice and recognition as a valid tikanga practice remaining constant. Under the Adoption Act, whāngai arrangements are expressly stated to be of no force or effect, meaning matua whāngai are left without legal rights that other adoptive parents are afforded. For Māori, the current Act can be seen as privileging an outdated Western conception of adoption and familial care, while marginalising Māori childcare practices and the values of tapu, whakapapa, whānau and araha which underpin such practices. The issues Māori see in the Adoption Act are its focus on severing whakapapa and whānau connection, prioritising matua over tamariki and individuals over collectives, and traumatising adoptees.
Unlike other legislation and international conventions concerned with children, the Adoption Act does not define adoption, make the best interests of the child the paramount consideration, set out the Act's purposes and principles, give legal recognition to whāngai, reflect contemporary views and practices of open adoption, or provide for extensive participation rights for the children involved. We recommend the following foundational legislative changes that will guide the application of our two proposed reforms. Tikanga Māori has demonstrable values and practices that hold the welfare of the child paramount. Therefore, we propose that our reforms for tamariki are underpinned by the values of tapu, whakapapa, whānau and aroha. Firstly, we propose a shift from secrecy to openness that recognises parental responsibility as being transferred in law and in fact from the birth parents to the adoptive parents, but acknowledges that a birth family still exists and may have a role in the child's life. A definition of adoption will describe that the aim of adoption is to provide a child who cannot be cared for by his or her own parents with a permanent family. A paramountcy provision would implement this principle in New Zealand's adoptive legislation and would see a marked shift from a focus on the needs and desires of parents to a clear emphasis on the best interests of the child. Guiding principles for the best interests of the child would supplement this paramountcy principle. We propose that it is necessary for legislative reform to contain a guide of non-exhaustive factors that outline what should be taken into account when assessing the welfare and best interests of the child. A principles and purposes provision would be recommended to set out the purpose in an objects clause. The objects that we propose should underlie any new adoption legislation, emphasising that adoption is a service for the child.
We suggest that the function of the Adoption Act for Māori customary adoption should be to act as a mechanism of recognition and not attempt to define or confine what a valid customary adoption is. Other jurisdictions, such as Canada and Australia, have made strides towards legal recognition of the customary adoption practices of their Indigenous peoples. Such reforms have been developed through consultation with their Indigenous peoples, with a focus on upholding Indigenous rights, protecting Indigenous children, and promoting their best interests. Our recommendation is that Section 19 of the Adoption Act be repealed and replaced with a new Section 19. This section ensures whānau, hapu and iwi are empowered to determine for themselves a whāngai arrangement in accordance with their tikanga and give it the legal recognition it is rightfully owed. The additional steps required as part of notification is not to challenge or create an extra barrier for matua or matua whāngai, but to ensure the section is protected against misuse and ensure the best interests of the child are being served. While our recommendation has been informed by Māori perspectives, we recommend that further consultation must be conducted with Māori to ensure this reform is implemented appropriately. Legally recognising whāngai under our new Section 19 will promote Māori rights to self-determination by recognising and giving legal effect to whāngai and whāngai matua as defined by the tikanga of their whānau, iwi or hapu, and ensure matua whāngai have access to rights which will enable them to best care for tamariki. Waiora and Welamu have one son aged 4 named Tamaho and a newborn named Hemi. Now that Hemi has been born, Waiora and Welamu are struggling to financially support the young whānau. Whilst Tamaho is their taonga and they love him very dearly, they find that they cannot give him the full care and support he needs. After a collective whānau discussion, Wairoa's auntie Hini and her husband Ariki agree to raise Tamaho as their own. Tamaho grows up fully aware of his matua and learns all about his tribal history, knowledge and tikanga and te reo Māori. When Tamaho turns 6, Hini and Ariki consider adopting him. However, when looking at adoption, they are shocked to discover whāngai are not legally recognised. This is especially because the arrangement was in accordance with the tikanga of their iwi. In any event, they do not think that an adoption order accurately reflects their relationship with Tamaho as matua whāngai, nor his relationship with his matua. They do not want Tamaho to feel that he was unwanted by his matua, nor feel that he was severed from them. Tamaho's whānau feel trapped, as unless they undergo the formal adoption process, Hini and Ariki cannot access many of the legal rights they need to best support Tamaho in his upbringing.
Had the guiding principles and purposes been present in the legislation and our new Section 19 in place, the outcomes for Tamaho, his mātua whāngai and his mātua would have been more positive and meaningful. In considering his best interests, the court would see the whāngai arrangement and his mātua whāngai are providing a secure familial home. In considering the purposes, the court will see the whāngai arrangement is in line with the rights and principles accorded under Te Tiriti and international instruments. By enabling Hine and Ariki's whāngai adoption of Tamaho to be legally recognised, Hine and Ariki can secure legal rights equal to other parents that they would not have otherwise been afforded.
New Zealand's adoption law does not uphold children's participatory rights under Article 12.
The cases of Waverley v. Walter and Re E illustrate the inconsistent and often inadequate recognition of children's participatory rights under the Adoption Act. These cases show that the Act leaves child participation entirely to judicial discretion, resulting in uneven protection of children's rights. We propose that in addition to the Adoption Act 1955 as Section 10A be introduced, it would require social workers to discuss with the child the meaning, process and the effect of an adoption. This would be required to be added to the report a social worker has to provide to the court.
When we look at the benefits of a participation-based model, we can immediately see why this approach is essential. A participation-based model would protect children's rights, improve their safety, increase their stability, support their emotional well-being, respect their maturity and personal history, align adoption with modern New Zealand law, strengthen cultural and whakapapa connections, enhance fairness, and bring us in line with the international best practice and/or Article 12.
Eva Mason is 13 years old and has lived with her mother, who struggles with mental health and addiction. Throughout the process of becoming adopted, Eva has felt left in the dark. Her mum or any extended family did not have the capacity to explain to her. Oranga Tamariki only gave her limited information, and during court proceedings she had no idea what was going on. Everything seemed to be happening around her and to her rather than with her. Without the appropriate information, she did not get a chance to adjust to her new situation or process the shock of leaving her birth mother. The experience worsened her self-esteem, her ability to trust people and build new relationships. She struggled long-term with anger management issues and feelings of shame, guilt and confusion over what had happened. Had the guiding principles and purposes been present in the legislation and our new Section 10A been in place, the outcomes for Eva Mason would have led to a far easier transition into her new family life and prevented long-term negative mental health, emotional and social impacts for her. Because Section 10A creates a duty of care-based model on social workers, Eva's rights would have been a focus throughout the process, ensuring she was adequately informed, assisted and encouraged to participate throughout the process. This would have helped her come to terms with the adoption and preserved her sense of self-confidence, self-efficacy and self-worth.